I didn't know that many police officers 25 years ago. You know, I was not a perfect child or a perfect teenager or anything else. I was afraid of the cop. If I saw a cop, I wasn't like running up shaking his hand.
You were running the other way.
I was just making sure I wasn't doing anything that would call my attention to myself. What I've learned in these years of now representing all these guys is they're all human beings. I've never met one who was sued who didn't take it extremely seriously, who wasn't concerned. You can sue for anything. You want to sue for $10 million and they can take my house. So you're meeting them and you're comforting them and saying, we are going to represent you and take care of you.
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Niall Abuzaki.
We're back, RVA Trial Lawyers, and today we have David Corrigan with us. David, thank you so much for joining us. David, for those of you who do not know, is the managing partner and one of the founders of Harmon Claytor Corrigan Wellman, and of his many, many accomplishments, he is a fellow of the American College of Trial Lawyers. David, thank you so much for joining us. If you wouldn't mind just introducing yourself to our listeners.
I'm glad to be here, Sharif. Thank you for inviting me.
We're happy to have you. And so, David, I mean, we almost lost all of our good content before we even started this podcast, talking about what were we into, the Charlottesville case already?
We were in the Charlottesville case, but before we get into the Charlottesville case, tell us a bit about yourself. What led you to the legal profession?
So I'm from Charlottesville originally. It's my hometown and a place that I love dearly, and it's a place that got such a bad reputation out of those events that I was glad to be able to be part of setting the record straight in those cases. I grew up in Charlottesville for the most part. My father was in athletics. He was the athletic director at the University of Virginia, athletic director at the University of Notre Dame, commissioner of the Atlantic Coast Conference. I have 4 brothers, all of whom are involved in athletics. I played college basketball and lacrosse at Hampton-Sydney College. Was a teacher and a coach for a long time, for 4 years before I decided to go to law school. Nobody in my family's ever been a lawyer. And I went to law school because I wasn't sure if I wanted to be a teacher or a coach at whatever level, or just gave myself options. I thought, I couldn't be a doctor because I wasn't smart enough, so I figured I'd try law school. And so I went to law school, liked it, and then I realized if you go to law school, really, you're a lawyer. And so it has nothing to do with all those other things. Now, I've been fortunate to be able to coach my kids. I have 3 sons, and they all played sports, and I coached them, and I've been involved in athletics since. But when I went to law school, the only thing I wanted to do was be a trial lawyer. I mean, I didn't even know what lawyers did who didn't go to court. I didn't understand what the lawyer job was.
I think that's fair. I think all of us will probably say the same thing. I learned that the hard way, though, that not all lawyers are actually trial lawyers.
That is exactly right. And it's interesting you say that coach and teacher, but that's what true lawyers are. You teach a trier of fact about an issue that you have before you, or you're coaching someone to get from one place to another to resolve something to a better place.
Exactly. What was it that made you think, I want to be a trial lawyer?
Well, I went to the University of Notre Dame, and they had a really good trial program there, and so that was influential. Again, I didn't know what lawyers did other than go to court. At one point, I thought what I really wanted to do was become a U.S. attorney. When I was first graduating from law school, it seemed like the perfect job, because in my mind, the U.S. attorneys, the criminals that they go after, have chosen to be criminals. You know what I mean? As opposed to in state court, it sometimes feels like it's just some poor schmuck who can't get out of his own way, and now he's in the criminal system, and I always thought that would be a great job. But then those jobs don't hire you out of law school for those jobs. So someone explained to me what civil firms did, and they tried cases, and I thought, well, I'll just go do that.
And did you go to Richmond right after law school, or how did you get to where you are now?
So, like I said, grew up in Charlottesville, went to Hampton-Sydney College, then taught and coached at collegiate school here in Richmond. And then I went to Notre Dame, kind of after, when I was 26 years old at the time, graduated from there, and then looked around the country. Notre Dame's a national school, so we had firms from all over the country. And I looked around, and somebody said, you can't be a gypsy and practice law. You need to pick a home.
Right.
And I said, well, Richmond, Virginia is my home. So I came back here and been here ever since.
That's awesome. And was that the start of Harmon Claytor Corrigan Wellman?
I came to a firm called Browder, Russell, Morrison, Butcher.
Got it. That's where you know Brewster from, right?
I knew Brewster. I know Harmon Claytor Corrigan Wellman. All 4 of us were there. It was a firm of about 30 when I went, got up to about 60, blew up in the space of about 4 years. After it blew up, that's when Harmon Claytor Corrigan and Wellman, everybody had to go somewhere, and we went out and started our own firm.
That's awesome. And today, how many lawyers? About 60 or so?
We're right around 60 lawyers. And same dangerous side as the other one that blew up. So we're trying to hold it together.
Yeah, and I was talking to a friend who works there was it Tuesday night, Danny, before our presentation, Niall and I just, for whatever reason, the in a court let us present on voir dire, which was probably a mistake. But we had a good time doing it. But I remember Danny mentioning that you all just opened your Roanoke office. So you guys are really, it seems like nonstop growth.
Right. It's been a lot of growth. It's been, we've had a firm since 91. So it's 23 years or 33 years that we've had a firm. And, it was kind of slow, steady growth. It's been a little faster recently.
And is it primarily civil defense work?
Exclusively. That's all we do. Civil litigation.
You've got a special niche with dealing with or representing local government, police officers, teachers. Can you tell us a little bit about that?
So I was a trial lawyer, like an insurance defense type of trial lawyer when I first started at Braddock Russell. The first 30 or 40 cases I tried were car wrecks or slip and falls or things of that nature. I enjoyed it, and I liked it in part because you got into court, because it's much easier as a criminal lawyer to go to court. As a civil lawyer, you have to find cases to try, and we were able to do that. But when I was in law school, I had worked at the city attorney's office in South Bend, Indiana, where the University of Notre Dame is, and that was the first time I'd ever heard 1983, the whole idea of 42 U.S.C. 1983, civil rights actions, the United States Constitution, interaction between the citizens and the government and lawsuits. And I was fascinated by it and thought this is a great area of practice. When you go into private practice, that's not the kind of cases you get unless you figure out some way to specialize. Over time, I was able to merge my trial practice with that interest, and through connections with local governments and the insurance plans, the Virginia Risk Sharing Association and VACORP and Division of Risk Management, who provide the insurance for all those entities across the state, and then the local governments themselves. I was able to develop that practice.
And my understanding is there aren't that many practitioners who really specialize it, right, on the defense side and the plaintiff side.
Right. There's a group of us on the defense side, but it's not nearly as commonplace as kind of the regular insurance defense group. And a lot of them came from local governments where they actually were doing the work, like the bigger City of Richmond, Henrico, Chesterfield. They have city or county attorneys' offices that handle their cases.
Got it. We already have a list of cases we'd love to ask you about, but before we get into that, qualified immunity is a massive part of 1983 cases, right? Would you be able to, help us understand what qualified immunity is and its practical effects?
And let's start with 1983 cases. So when is an officer exposed to a 1983 civil suit? For those that are not very privy to it.
Right. So the police interact with the public all the time. And the Section 1983 case is based on an allegation of a breach of a constitutional provision. And the 42 U.S.C. 1983 allowed people to pursue constitutional claims. And originally I thought it was just against the federal government. Turns out it's against the state and local governments as well. That's been the law for a really long time. So that's the exposure. And it's any time there's an interaction. The typical cases, a lot of ones that everybody hears about, are the excessive force cases, where the allegation is that they used excessive force and violated the 4th or 14th Amendment in that respect. But there's also, certainly like a malicious prosecution, false arrest, false imprisonment, all those type of claims where, again, they're alleging under the United States Constitution there's a claim. And the qualified immunity, what it means is it's a two-level inquiry. The first inquiry is, was there a constitutional violation? Did the officer violate the constitutional rights of the individual? The second part of it is, was that law clearly established? Because what they don't want is every time an officer does something, if he happens to make a mistake, the kind of thing, every time they make a mistake, you sue him. Can you imagine how many suits there'd be? I mean, every time anybody got arrested, you say, well, I'm suing the officer. I don't think this was right. If it's right or wrong, the case would go forward. What they wanted and this was judicially created, the idea of qualified immunity was, they wanted it to be only in situations where the officer has clearly done wrong, clearly established law has been violated. You should have known. You knew you couldn't do that, and you continued to do it. And in most of the cases I've had I've had a lot. I mean, our firm's probably had 1,000 cases, like representing, again, all across the Commonwealth over the space of 25 years, a lot of cases. But a lot of the more well-known ones, it deals with circumstances in the use of force and judgments and There's case law out there that says, we don't, the judges sitting in the comfort of their offices don't get to look back and say, well, I think he should have done this. There has to be a clear violation, something that is, because everything's so fast and sudden, and, it can be dark, and there's just a million circumstances around what the officer is confronted with.
Can we talk about the scope of what constitutes clearly established? My understanding, again, I've dabbled in this work and will likely never dabble again, but thank gosh we made it out alive. My understanding that it's often geographical. I mean, when you're looking to see whether a law or whether the constitutional right that was violated was clearly established, you're looking at that state jurisdiction and that federal circuit. Is that more or less correct?
I think the real analysis is you look at the specific facts of your case. Right? It's not just like every time a police officer puts cuffs on someone, there's handcuff cases, there's whatever. It's all the specific circumstances. Was everything in place that he should have known that he was doing the wrong thing in that moment? That's more. But yes, I mean, in the Fourth Circuit, there's a set of law, and there's a set of law in every circuit across the country. But there's been enough United States Supreme Court cases that we have a lot of guidance from the United States Supreme Court about where the line is. Does the factual scenario have to be, I guess, for it to be considered enough that it's clearly established for a certain violation? And I recognize that's a bad question on my part and it's hard to answer, but isn't that a lot of the fight, is whether that fact pattern, I guess, fits within the scope of what was considered clearly established law? Right. Yeah. So in any given case, and if you're a plaintiff's lawyer, which is a much harder job in these contexts, because you have to prove all these things and overcome qualified immunity. And qualified immunity is a defense, so that the officer has the burden on the qualified immunity, but it's out there. You need to get real specific. You need to get real deep into the facts and prove every little aspect. If, he did this thing, this thing, this thing, this thing, and, collectively you add them all up, it can be enough to amount to something that is actionable. But a lot of times, if you try to limit it to just a single act, you're going to be hard pressed to prove that what happened in that one single thing was not clearly established, or was something you can proceed with.
I know one of the criticisms of qualified immunity is that the court can go straight to the clearly established analysis and basically bypass whether or not what was asserted was actually a constitutional violation, which the criticism's been, by allowing that to happen, there is less case law establishing what constitutes constitutional violations. Why is that? And I guess, what are your thoughts?
I mean, as a defense practitioner,
it's great, right? I mean, yeah.
My thought is, it used to be they had to go through both, and to say they had to or didn't have to, is the Supreme Court guidance on this. United States Supreme Court guidance on this was that you go through the first analysis, then you go to the second analysis. But over time, they're like, why go through the first analysis if the second analysis is clear that the right wasn't clearly established? And why go through the process? The criticism is a legitimate criticism, that there are these circumstances, if they're significantly different than the existing case law that you're relying on for clearly established law, you should go through that to show whether or not the constitutional violation occurred or not, for guidance for future courts and for practitioners. I think it's a fair criticism, but
it's interesting. It's it's a really, really complicated and interesting practice area, but it's also fascinating.
We went deep quickly here,
David, and I'm going to
into the qualified immunity.
Yeah, now why don't you save us a little bit? Come back and talk about fun stuff. I'm never taking another one of those cases again. By the way,
there may be people who aren't that fascinated by that.
Exactly.
I'm comfortable with it because that's what we talk about.
Let me reel you back. So for me, I look at it as a human element, and you touched on it. How judges, from their bench, and after getting briefs from both sides, decide whether or not an officer violated 1983 Civil Rights Act. What we lose sight of is the fact that these officers, we expect them to be these legal scholars on the side of the road when their life is on the line. And many people don't know that every time an officer walks up to a vehicle, an officer finds a way to leave either their fingerprints or DNA on a vehicle. And that's the lens that they walk. towards that particular forceful police encounter, literally with the fact that, hey, I may not walk back to my vehicle because I may lose my life. And I'm going to leave some evidence for someone to try to figure out who actually may have taken my life.
Right.
So for me, it's, I instruct a lot. I instruct the police on both academy and in service, on Fourth Amendment. But often we lose sight of the human element when emotions are involved. How do you bring the human element back in to say, albeit, yes, there is clearly established laws in place, but did we expect this officer to do the legal analysis that we're doing today?
So just to back all the way back, like the case comes into our office and whatever's happened has already happened, right? The encounter between the citizen and the police officer has already occurred. And whatever, if there was use of force, there's a shooting, if there's whatever has happened. And the officers, we're hired to represent the officer. So he comes into our office. You talk about the human element. And people, I didn't know that many police officers 25 years ago. I grew up, I was not a perfect child or a perfect teenager or anything else. I was afraid of the cop. If I saw a cop, I wasn't like running up, shaking his hand.
You were running out of the way.
I was just making sure I wasn't doing anything that would call my attention to myself. What I've learned in these years of now representing all these guys is they're all human beings. I've never met one who was sued who didn't take it extremely seriously, who wasn't concerned. They've been sued, and you can sue for anything you want. They're sued for $10 million, and they can take my house, and you have all these concerns that these individual officers have. So you're meeting them, and you're comforting them and saying, we're here to represent you. We're taking the burden off you of worrying about this. You now have a lawyer, and we are going to represent you and take care of you. And then we want to go through the story. And for sure, I've had cases where officers behave really poorly. Really poorly, like intentionally poorly. Whether it was a bad day or it was just a bad guy, we've had those cases. They're bad. They're also very rare. Almost every instance, the police officer doesn't go to work that day saying, I hope I get in a fight or shoot somebody today. I've never had that case. And so the human element is exactly what we're talking about. Who among us has a job when you go to work where you might end up in a fight, getting shot at, having to shoot someone, all these things? None of us. These are people who are frontline, dealing with every time they walk up to a car, something could happen. And sure, most of the time it doesn't, and most of it's a pleasant encounter, but they don't know. And so they're on guard. And absolutely, they are being held to a standard of you better know every law and whatever thing that you're doing might violate somebody. Another part of this human thing today is people are not anywhere near as respectful to the police as they used to be. During the protests, we had we talked about Charlottesville in 2017, where we represented 100, 150 Richmond police officers in a whole series of cases in 2020 rising out of those protests in the city. And the behavior of the people towards the police was amazing to me. And the police can't react. They can't do what a grown man would do if another guy walked up to him and said the things that was being said to him. They just have to be professional and do their jobs. And so there's all the human elements. It's all part of what we do and part of what we help them deal with. And it's very traumatic. I don't think you would necessarily know that if you ever met the cops or saw them or anything else. But we get them at their, it's like a lot of times with people who do our jobs as lawyers, people are on their worst day or on a very difficult day. I'm talking about one of the hardest things I ever encountered in my life. Can you help me? There's your human element.
Every time I start an academy class, I go around the room. I'm like, look, what I'm going to teach you, you're going to forget a few hours later. But the interaction of me getting to know you as a human and why you're here, why are you seated here? To do a job for $60,000 a year where you're going to be risking your life every single day is what I care about. So I go around, and the last question that I want them to answer is, why do they want to be a police officer? It has never failed that the common denominator is to help.
Absolutely.
To help and to make a difference in the community that they live in. It's mind-boggling to me. And I'm like, that's where they start. And I often say on the hard days when you're asking yourself, why am I doing this? Ask yourself why you started. And we're back to that common denominator, and that is to help. So talking about some of your cases, and we discussed Charlottesville, I brought up the fact that you're a trial attorney, and just like there's a common denominator to help, there's a common denominator among trial attorneys, and that's that competitive nature. Let's talk about being a trial attorney. What led you to want to just be in court and represent?
So having talked about sports, I grew up in a family with 4 brothers, and we all played sports, and my dad was involved in athletics, and competition was a way of life, and it still is for me. I'm 67. I play in a 60 and over basketball league and play pickleball and tennis, and anything you can compete in is fun to me. Trial work is competitive. But at the same time, and I care about this, it is just like with true competition, there's rules and there's good sportsmanship and there's a way you're supposed to behave inside of the competition. Equally important to me. I want to win. I do not like losing. But at the same time, I don't like cheaters. I don't like people who, break the rules or act like they're not breaking the rules and they really are. I mean, it's all equally bad to me. In fact, it's worse. The smarter they are and the more you can't trust them, the worse it is. Guys who aren't smart enough to know what they're doing and make mistakes, you can understand that. But people who are intentionally violating the rules, I don't have any time for them. But all that just keeps life interesting. And it's like it kind of stokes the fire every day. You go in there to do the best job you can. And then the other piece is the whole thing we talk about with the clients. Representing the clients, helping them through one of their worst days, get them to the other side where they can say, glad I met you. Don't particularly like lawyers. Glad I met you. Glad you were able to help me with this situation.
Looking at, you told us you're 67 years old. You've been doing this for a long time.
Yes. Let's
talk about some cases that stand out in your mind.
Yeah. Can we talk about the Charlottesville case? I know we've referenced it a few times.
Sure. So my involvement with Charlottesville, we were hired through the insurance plan to represent Chief Al Thomas. He was the chief of police at the time in Charlottesville. And they were confronted as, they had a series of protests up there of different types over this period in advance. And then the big one was going to be in August of 2017. And of course, we mentioned the night before the people marched on the University of Virginia, and that was not a city involved situation.
Albemarle County.
Because the Charlottesville's, the university's in there, considered to be in the county, even though it's kind of in the city, but whatever. But the big event on that day, and of course, the night before, the federal judge said, because the city had said, why don't you go to McIntyre Park and do this instead of doing it in town, in the town, the park right in the middle of town. And the federal judge said, no, they get to do it where they want to do it. That's where their permit is. So it was on. And then they had to figure out, how do we deal with this? How do we deal with all the Unite the Right people who are coming and all the people who want to protest the Unite the Right people coming? And for sure, and we talked about this, there were people on both sides with bad intentions that day to show up and to encounter the other side in some physical manner. And it happened. And the plan, which was, has been documented what the plan was to try to keep them apart if you could. But if they came together, when they came together, declare unlawful assembly and get everybody out of there. That was the plan. And that's what they executed. And from my perspective, it hadn't been for, and it's horrible, the car killing Heather Heyer and that whole thing there. What happened was remarkably less violent than what could have happened when you have all those people there with guns. I said to you, my worst case scenario, having been involved in these cases, was what if somebody had fired a shot and what if it turned into a gunfight? There could have been 20 or 50 people shot because of the amount of firepower that was present there, both with the police and with other people who were lawfully carrying guns. None of that happened. But it's like the thing got a worse review than it deserved in my mind. And I'm representing the guy who was part of the planning of it, but it was unprecedented too. It wasn't like there was a plan out there that everybody said, oh, if this happens, here's what you do. They were having to put it together. You can imagine coaching a football game, and it's the first ever football game. How do we do this?
Right. What were the lawsuits about? What were the allegations?
The allegations, they were from across the spectrum. There was one guy who had been hit by the car who sued and said that the chief of police was responsible because he had not provided adequate safety and security. And that was basically what all of them were about. There were people who got into fights who were Unite the Right people who had been injured, who claimed that the same thing, that they had not been protected properly. There were people who were members of the Unite the Right who got into fights that claimed that they were not protected properly. And Kessler, who was the guy who had the permit, he claimed that his First Amendment rights were violated. And we won all of them because it was not the fault of Al Thomas that this occurred. And one of the things that people don't appreciate is the police, they don't have an obligation to protect you from each other. They have an obligation, their duty doesn't run that way.
It's interesting you say that because that's how the community saw it. The community saw that the police should have done more, especially what happened on August 11th, right? Because when they started in No Name Field and then marched through UVA campus, the police didn't do much. And you could see that when the Unite the Right rally made it around the Thomas Jefferson statue, there were some kind of protesters, and some kind of protesters then were assaulted, which led to the calling of an unlawful assembly, which then everyone dispersed. So many, after seeing what unfolded the night before, expected the police to actually protect the people from the other people, or the Unite the Rally protesters from the counter-protesters.
What's the constitutional violation that they alleged?
In Kessler's case, it was a First Amendment right.
Right.
In the others, it was the Fourth and 14th Amendment, protection of their person, essentially, was what they were alleging.
Those are interesting theories. Because, I'm thinking, man, well, how do you show? One, you got to show negligence, and you got to go show foreseeability, then you got to show causation. Those seem like very, very difficult cases. How far did they get? It sounds like probably not far at all.
Everything was dismissed at the motion to dismiss stage, or at the demurrer stage, or a special plea of immunity stage. Only one of them was a state court case. All the others were Fourth Circuit cases. And they were all dismissed at the motion to dismiss stage. And, and then the Fourth Circuit affirmed in each case.
And not to go back down the rabbit hole again, but I guess I can't help myself. But my understanding is that if qualified immunity, for example, ever is not given, is an interlocutory appeal is a matter of right for the officers? Is that?
Yes.
Okay. Got it. So that, I imagine at some point these cases can take forever, right?
They can. And it's most often qualified immunity is raised at the summary judgment stage, right, when all the facts have been developed. In these cases, it was at the motion to dismiss stage, because whatever facts you can create, you don't have a constitutional violation. That's what was found. There was no constitutional violation.
Right. So it didn't even get to the qualified.
Established.
Okay. So did the court come back and basically say, here's two? I recognize there are multiple cases, but I imagine the court, when I clerked for the federal court, we always wanted more than one reason in case it went up to the circuit court.
Right.
And so I imagine the court in those cases came out and said, failure to state a claim plus whatever the qualified immunity analysis was.
Right.
Okay. That makes sense. Did the Fourth Circuit, did they affirm on both, or did they?
I haven't read these cases that we were in. It's been a few years. My recollection is yes, that they affirmed on both bases.
Or, I imagine what...
And there were supervisory liability claims that were made, and all of it was affirmed.
Right. Gosh. Yeah, those sound like...
It was Judge
cases.
Moon was the judge in Charlottesville who decided all those cases, the federal cases.
How many cases, these types of cases, are you guys handling at any given time?
There's like 5 partners on the team, and then there's 4 associates. So, and we all have, I don't know, a couple hundred.
That is wild.
Yeah. At different stages.
Right.
But yeah.
That is wild.
Yeah.
It's just amazing.
One of the things in my lifetime has been how much more prevalent it is, how many more suits are filed. And again, we haven't talked about this aspect of one of the things we do is also represent schools, school boards, school teachers,
right,
people like that. People sue the school all the time. And like 25 years ago, somebody sued the school or sued their teacher, or sued the principal or the superintendent or any of that. That's commonplace now. If something doesn't go the way someone likes, then one of their things is, I'm suing.
And it will be a 1983 claim, right?
They're a 1983.
Right, because otherwise you're running up against immunity.
Right. Yeah, the school board itself in state court claims is immune. But then you go after the individuals under, again, state law, where you have the James versus Jane test with the 4 parts. And it comes down typically to whether the person was exercising discretion, to whether they're immune from simple negligence, which makes you have to prove gross negligence, which is a heavy burden.
Right. Now, in terms of Who's paying the bill for representing these teachers, representing the
Us.
officers?
We get paid either by the insurance plans for the smaller governments, or if we're hired directly, we get paid by the local government, by the school board, or by the county or the city or whoever's the employer of these individuals.
And does the employer typically, or is it standard for them to indemnify their employees so that
Yes.
in terms of
And the only time they wouldn't, and you run into this if,
scope issues?
well, criminal acts kind of thing, if the
outside of
employee,
Yeah.
I mean, not just like, I mean, if you're alleged to have injured someone by accident, you weren't hired for that purpose, but you're not going to lose your indemnity. But if you intentionally did something, then there's a lot of times there will be no coverage. There'll be no defense. You're on your own.
It's fascinating.
So, David, we talked about us being trial lawyers, and what part of a trial do you enjoy the most?
We tried a case earlier this year, so I'm a little fresh. It was about a 4-day trial. It was down in Lynchburg. It involved a registrar who sued the electoral board members, alleging that she had been not reappointed for political reasons. And it was a First Amendment violation because you're not allowed to do that. You're not allowed to fail to reappoint the registrar, which reminded me of the parts I like. And Blair and I tried that case together. Blair, who you know, Blair O'Brien. And we split it up. And so I'm fresh on my mind of which parts do I really like the best. And, you know, there's the, like, 4 big ones are, right, the opening, the closing, direct exam, cross-exam, right? And it's direct exam of the other side's witnesses, or cross-exam of the other side's witnesses, which comes first for us because we're the defense, and then direct exam of our witnesses. So, like most people, closing and cross-exam are more fun than opening and direct exam. But they're all equally important, or you could argue that the opening is the most important because once you finish that, those 7, 8, 12, however many people are on that jury have a definite impression of what happened, and you've created it. And if you haven't done your job and the other person has done their job, you may be fighting an uphill battle before the evidence is even in.
Right.
But it's more fun to give a closing because it's freer. You don't have to. You're not limited by what the evidence will be. The evidence is in, and you can now, talk about the significance of it and where it fits and why it's important.
Was this a federal court trial?
It was.
How does a voir dire work in federal court? I mean, it's very judge dependent, correct?
Very judge dependent. Yeah, this was a judge in the Western District. The most interesting part of it was that we started out with 44 jurors, and he struck 4 for cause. And then we picked our jury, our 8-person jury, from the remaining 40. So we each had 16 strikes, which I've tried a lot of cases. The most I've ever had was 3. Having 16 strikes was the darndest thing I've ever experienced. But we got through it.
Did you all have opportunities to actually speak to the jury during voir dire?
We gave him questions, and then he allowed each side to ask some follow-up questions. So he asked a bunch of questions that we provided, and then each side had an opportunity to ask their own questions as well. But it's, this is Virginia. This isn't California or whatever. It's not going to go on for days.
Right. And California is known for days, arguably too long, right? It depends. But one thing that is interesting about Virginia is, despite at least the code on voir dire being fairly broad, I mean, it's just not very restrictive, I think the practice of voir dire jury selection in Virginia is very restricted. And I wonder, I mean, now and I have a little bit of a crusade going on to try and change that. But I wonder...
You want more voir dire?
I think we want more leeway in voir dire. I think if I were to be, being candid with you, I think the most important parts of the trial is voir dire and opening, without question. Not to say that, and it's for the very reason that you mentioned a minute ago. It's if you're able to frame the case from the beginning and basically take the lead while the other side's going to fight an uphill battle, right? Because now you're not just dealing with making arguments you're also to persuade, right? But you're going to have to get these jurors to say, wait, my initial impression was wrong. So then the ego gets involved. And then when the ego gets involved, me especially, double down, right? Like we don't want to change our mind. So my thought is if you can get ahead in voir dire and then carry that through opening, I mean, you are way ahead of the game. Yeah, and I think depending on the judge in Virginia, it really depends whether or not you're actually able to do that.
And I've sat on some panels with judges and other trial lawyers and stuff talking about that very thing. And a lot of judges are very conscious of not letting you get an advantage. They want you to do your job. They want you to have a chance to ensure that you have a jury that's impartial, but they don't want you to try your case in voir dire. And I agree with that.
Oh,
but don't get me wrong.
No, we agree with it as well.
If the other side's doing it, I'm doing it too.
Yes.
I'm not gonna let them do it and me not do it. But neither one of us should. It's kind of my fair play thing.
Yeah, well,
it's really not fair play to try your case.
It's not effective. I mean, the idea that a juror comes into the courtroom and you're going to change a strongly held belief they've had for the last 45 years of their life is just nonsense, right?
Sure.
So, I think if we don't, at least from my perception or my perspective is when I go into jury selection, my goal isn't to persuade. In fact, I want to hear the dirt. Like I want to hear, how much you don't like my case, right? Because I don't want you on the jury, right? And so I think it is a fool's errand to try and to even think that you can persuade a juror during jury selection. What I've run into a lot is judges are very used to the standard kind of voir dire. Raise your hand if you have a family member or friend who's in law enforcement. Raise your hand if you've been in a car crash before, right? And so when you start deviating from that, I've gotten pushback because they're like, well, what are you doing? Are you trying to argue your case? This is going to take too long, all of that. And so without diving into our whole, what was it? It was supposed to be 45 minutes and lasted an hour 15 thing on voir dire on Tuesday. I think there is room in Virginia for there to be a little bit more expansive voir dire, or at least for counsel to have more leeway during voir dire. And I think the code section actually supports it, but in practice, we don't see it.
Yeah, I agree.
I think I haven't done as much criminal law lately. In fact, in the last couple of years, but for the first 6 or 7 years for me, that's all I did. And I did think that the criminal cases, there is more leeway, especially for the defense, because the last thing that the judge ever wants to happen, right, is some sort of allegation on appeal that the defense didn't have a full and fair opportunity to present their case.
I mean, often the prosecutors kind of warm up the jurors because we go first.
Right.
And when they get comfortable talking, then the defense stands up and they're hearing everything then, right? For us, it's how do I exploit weaknesses in my case and see how the jurors see them at the outset. The jurors are not experts. And when they come in, granted, every jury verdict that I've received, I've been satisfied. I'm like, you know what? I would have done the same. So I think we have the greatest system in the world, and there's no close second. But at the same time, there are some issues that I feel that you have to exploit, especially if you're doing, for example, like a child sexual assault case. What do they expect from this child that doesn't have a frame of reference to what is sexual touching? And do we bring that out? Or do you bring an expert to bring it out? Or if people have strong beliefs around firearms and the government cannot in any way regulate that. And if I have, Second Amendment guys on that says, hey, it doesn't matter if you're a convicted felon or not, they should still be able to possess a firearm. I want to know that in war.
And be president.
Are we taking that out? So that's what we're talking about here. It's for me, it's what are the weaknesses or things that I have to make sure that I don't keep a juror on there that has this, conviction to something that I can't overcome through my evidence and then in my argument at closing.
So when you're representing police officers, what are the questions that you want asked during voir dire?
Well, I agree with what was being said, that you don't want anybody that doesn't like your client or doesn't, and making sure you get that out, asking enough questions to ensure that there's not someone on there with hidden agenda, whatever you want to say, who's thinking, I don't have to raise my hand yet. They haven't said anything that I have to raise my hand yet to. You want to make sure you get deep enough, particularly with the police. Police can be, pretty controversial. There's those, I've talked about my cases in front of my friends sometimes, like no names or anything, but just like, here's the scenario. What do you think of this? And some of my friends are like, I'm with the police. Like their hand goes up like that. That's their answer. Other people are very conscious of the rights of the individuals and they don't trust the police and all that. You need to know that, right? If you're going to represent a police officer in a jury trial, you need to know what the feeling of the individuals on the jury are, and that none of them they don't have to all be, I'm with the police, but what you don't want is somebody says, I don't believe a word the police says, or I don't think cops lie all the time, or all that kind of. You can't have those people on your jury. How do you suss them out is the question.
Right. No, it's interesting. Well, this is what keeps the job fun, right? I mean, gosh, imagine not being a trial lawyer. I couldn't do it. I don't know what I would do with myself.
Well, it's so funny when you guys, we talked about me coming on here, and I told you I listened to Craig Cooley and Learned Berry, and I've tried like more than 100 jury trials, which is a lot for a civil lawyer. Those guys have 600 and 700 murder trials.
Right.
So I was just like, you realize a whole different level out there of guys who really have talked to a lot of juries about a lot of serious things.
No, and it's really cool for us because we're getting consistent answers, right? About opening being very important, voir dire, and just the things that you see both in civil cases and in criminal cases that are necessary to get success in a courtroom. Right. That makes me think of, I think, a very important thing. So how at your firm do you guys help your lawyers, your younger lawyers, like just get even a fraction of that experience? Because one concern that I have is that young lawyers today just aren't getting in the courtroom nearly as much, especially on the civil side.
I agree. It's a big concern. The good news is there is a general district court. So they do get to go there. Getting jury trials is more difficult. And of course, they've upped the jurisdictional amount in general district court to $50,000, which is a lot of money to have, no discovery and all these other things that are going on. So I think it's a boon to the plaintiff's bar. I think it's why it exists. But they are getting that experience. So we have clients that send us cases that are that small, and if they're appropriate to be tried, we try to get them tried. I know when I was young, I was trying to find cases to try and trying to make cases go to trial because I wanted to go to trial because I wanted to find out if I was a trial lawyer or not, kind of thing. I don't know if there's as much of that same mentality. You have it, I think, Sharif. But I'm
crazy. I mean, and Niall is too. I mean,
unfortunately for me, my trials keep coming. Whether I want them to go to trial or not, they keep coming.
Right. But on the civil side, and there's firms out there. There's friends of mine, Hank Carter and Tyler Shands. Those guys have tried like 1,000 cases, literally 1,000 cases to a jury. A lot of them are car wrecks or whatever, but they go to jury, they go to trial all the time, and their guys in their firm go to trial all the time.
No, that's right. And we know them.
Yeah, and they're used to it, and it's harder for us, but we are getting that opportunity. And you also take them with you. And, when you have a trial, try to bring somebody with you to get the experience, at least see how it works.
For the young lawyer who is in law school now and is thinking, you know what, like I want to be a trial lawyer, what do you tell them to do? Like, I mean, career-wise, do you have any recommendations for where they should be looking, what type of job they should be trying to line up?
Well, if they're like perfect in every way, I think they ought to come to Harmon, Clay, Corrigan, or Wellman and work with us, and we'll get them in the courtroom and give them an opportunity. If they want to try a lot of cases and be involved, I think being a prosecutor is a good place to go.
Do you have a lot of lawyers who have made that jump from criminal prosecution or just criminal law in general to?
I think we have 2 or 3 or 4 who've done that, and they have no fear, which is definitely a good thing. They're absolutely ready to go to court, and that's a definite positive.
So, David, we talked about trial work, and also before we got on, we talked about. I want to hear about a few cases that stand out in your mind, and maybe 1 or 2 that when you look back 20 years from now, like, what, I'm proud of what I did in this particular case. Which cases come to mind?
You asked that, and my answer to you was, it's much easier for me to remember my losses and everything about the loss and why it was a loss and how we lost it and that kind of thing, and the details. On the wins, I think I don't know if it sounds self-serving, the best part, if we win, because when we did win a defense case, nothing happened, right? The plaintiff wins, it's $1 million or it's whatever, and everybody's hugging and whatever. When we win, it's just like, it's over. They didn't get anything. We're going home. And it's the gratitude of the clients, really, who have been under the stress and feeling the pressure of it. I can remember, I tend to remember more like funny stories, to be honest with you, than I do.
We're all ears.
Right. I had a case in Judge Dick Williams was a federal judge, and I was going to trial, and I was representing a braces manufacturer. The company manufactured braces. and an orthodontist was claiming that all his cases had gone bad and it was the fault of the braces manufacturer. So he sued for, I can't remember how much it was, but not an insignificant amount of money for all the cases that he'd lost. And he had sued a previous company that he had a relationship with for the same thing. And so I went to Judge Williams. I said, I want to prove this other one. And initially he said, you can't. It's a prior bad act. It's unrelated. And I said, no, it's a custom practice or policy. So anyway, he ruled against me at first. And I came back with a motion to reconsider. And Judge Williams had this unique way of talking. And he goes, Mr. Corrigan, you're trying to tell me there's only two possible reasons that that I could reverse myself, and that is if there's new law or if the court was wrong like that. And I said, well, I'm going with the second one, Judge, like that. And, which was, a little bit bold. And he reversed himself. So he let me do it in trial. So we get to trial, and the other lawyers obviously hates the fact that we're going to talk not just about his client saying all these braces are bad, but saying the old braces were bad too. So I got his guy on cross. I'm asking him questions. And as I ask him a question, the other lawyer stands, objection, object, Your Honor. And the judge says, we've ruled on this, sir. And he sits down, and I keep going. He asks again, and he objects again. He says, counsel, it's in the Dead Sea Scrolls that I have ruled on this. And so I keep going, and he gets up a third time, and Judge Williams goes, Marshal, like that. Well, the marshal is sitting over there. I think he's asleep, and he bolts out of his chair. Anyway, of course, the end of the story is I won. So that was a great. But I just remember sitting there and thinking, you can't make this stuff up.
No, you can't. That's what keeps the job fun.
It does. That part's fun. The clients, the gratitude of the clients, and for me, honestly, at this point in my life, and you met Blair O'Brien, who's one of them. We have a bunch of great lawyers on my team. Jeremy Capps, Scott Fisher, Blair O'Brien, Missy York, Leslie Winterberger. I've helped all them with their careers, and it just means everything to me to have been able to have that opportunity. It's the greatest legacy I'll ever have, more so than some case I tried. Watching them be successful is, and I don't want to overstate it, but because they've done it. It's not because of me, but I've been able to be part of it, and it's really gratifying.
David, as we come to an end to this interview, what is something that you like David to be remembered with as a human and a trial attorney outside of what we've discussed?
The only thing I'll say is this. The only thing that matters is your name. The only thing you have is your reputation. The only thing you have is your word. And I'd like to think that, and I know that people like good or bad say one thing about him, he'll tell you the truth, whether you want to hear it or not. And that would be my legacy, I think, more than anything else in my practice of law was that I never, you could always trust what I said, and that, and it was really important to me. And, I'll say this, attacking me on that is the one way you can get to me. Because you can say I'm wrong about the argument or, whatever, but to come after my integrity that's something I can't tolerate. It's the most important thing to me. Always has been. I knew that when I first became a lawyer. Like people will tell you, you can get away with this or whatever. I said, I'm not interested in getting away with anything. I'm gonna lead with my chin. We're gonna be real clear about what's being said and what's being done, and I think that's the most important thing. It's something we've tried to do with our firm too.
There's a practitioner in our community that we started this podcast with who said, you can spend a lifetime earning your standing in court, and every time you stand before the court, you are earning your standing in court, and you can lose it in one stand. And it is so true.
It absolutely is. I mean, you build your whole life around that concept, and then don't do it once, and it all means nothing, which is pretty scary.
Well, we appreciate you speaking the truth. We appreciate you being with us today, and we appreciate what you do.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's trial lawyer podcast. For more episodes, check out rvatriallawyers.com.